Who was here last time for part 1? 1, 2, 3. Okay, half. So for you, I have to say a good thing. You have already the pre-knowledge, and for the others, I have to say I'm going to repeat everything that you need to know for this. Those workshops are pretty independent, so it's not necessary, but of course it helps since the law is all tied together, and it's never hurts to know the law. We have structured the workshops in 3 parts, and the last one was about founding. So behind us we see and we sometimes hear a construction site, so this is kind of the image I like to use of a startup is a building that you construct and that you have to lay the foundation. So if you have a look afterwards or you've seen it already, they're laying the foundation right now and they're really doing a thorough job so you don't mess up. And this is the same with a company. You have to do a good starting and not just start right away how you please to do, because those mistakes can come and costly. The second step is growing, so you need a lot of people to help you build this startup, this vision, that skyscraper of yours for the future. And these people, you cannot do it alone, are employees, are freelancers, and we'll talk about how to hire them, what the steps are, what the legal implications are. And third, next time you need the money to pay those people, so funding is going to be an important issue. But let's focus on part 2 now. Actually, let's go back really quick. If you missed part 1, you can see it on YouTube. The link is also on legalstraße.com. It's put up wherever the relevant parts are of the contracts. And also you can follow the family, and they have it all set up on YouTube. And the slides are also on SlideShare. And that's exactly the same thing that we're going to do today. If you feel like you missed something that I said, of course you can feel free to ask in the aftermath. But if there is something that you need to review, you can review it on YouTube, and you can also look at the slides on SlideShare. I'm going to put up next week or so. All right, so if you have any questions, you see we have a lot to cover. Please remember them until the end. Then we'll have an open Q&A section, and if it's something that is not relevant to anyone else and it's private or something that you don't want to share with everyone, just come to me afterwards or send me an email. See my email address right at the bottom right corner, daniel@streiflaw, and just anything. Also feedback about the presentation, you could put it up on Meetup, and anything that is related to it. Okay, so first we're going to talk about a quick review on why you need Legal Straße and how it works, so everyone is on the same page. I'm not going to do too much review for those who've been here today. It's not going to be more boring to you than anyone else, so it's all equal. Then we'll talk about the big issue that I see that people mess up. What's the difference between employment and freelance and corporations or other companies? That you really get this right is a crucial point and a reason why a lot of startups fail. Third, we go through the documents of legalstraße.com. It's start with the employment contract, go through freelancer contract, and end up with employment participation. And that is a topic that is related because, of course, you deal with employees, but it's really specific too. So we'll kind of get to the corporate side of it again. All right, let's go. So the reason why you need Legal Straße is that most startups fail, and I believe that a lot of them due to a lack of legal infrastructure and knowledge. Of course, there are other reasons. There is team, there is a bad idea. You all know those people. But it's sometimes, we just want to, I have the opinion that sometimes legal issues are the reason, and we want to bring that number down and bring the startups that make it up. So you don't end up like this construction, you want something better, and this is why we have Legal Straße, to give you the infrastructure, meaning the contracts, and also the knowledge how to use those contracts, and which is both together is important. You cannot just have the contracts and not use them and enforce them, and just the knowledge without anything to back it up just doesn't help you a lot either. All right, why do you need Legal Straße? To avoid the pitfalls, to not make the mistakes that can be costly in the beginning, can ruin your startup, or that can, like in the end, really make a big difference. Second, we're free, so why not? Why not use it? You don't have to spend anything. Well, the reason we do it for free is that we hope to reach more startups like that. I think that knowledge for startups should be as free as possible. I think our hope is that you all grow, you all become successful, and then remember that we took a part in it. And also, having it free is kind of a part of the bootstrapping strategy, that you can stay finance it yourself as long as possible, so you stay in control, so you have enough, like you can really enforce your vision and follow through with it. And last but not least, join forces. I think this, like, if you share your knowledge, if you share what with other startups, then they will come back and they will, help you in the end. So as startups, you are the underdogs. You are the people who don't have money. You don't really have a lot of knowledge. You don't have the connections yet, and so you have to use of what you got. You have a vision, you have power, and you have confidence in what you can do. So you should all team up, help each other, and I think like a platform like Liegestraße will help you to do so. So don't be like very German and try to hide your idea and try to hide like anything and to be better than the others. I think like you all can accomplish so much more if you join together and really help each other out. And so the real enemy is not the other startups, it's maybe like the system that's helping or holding you back and not using your potential. All right, now you know why to use Liegestraße. I'll tell you now how to do it. It's really easy. Go to liegestraße.com. Then you will see this screen on the right-hand side. It's just a list of documents. You will just click on the one that you need and download it. And when you've downloaded it, or even in the browser, you can see the document, and there are yellow parts. You fill them out, and you use the comments to they guide you through the document, and so you know how to fill them out. And the documents that we're gonna use today or talk about today is the employment contract, of course, freelance contract, the private, what is it called, data privacy declaration, and the ESOP, the employment participation. All right. So let's go to the main issue that I see, the difference between employees and freelancers. And now a quick recap for those who've been here last time, or for all those who haven't been last time. Kind of like the structure of a GmbH and a UG is really important here to understand. This is the GmbH. It's a money head, and that represents that it's kind of, in the eye of the law, it's a person. It's a legal entity. And so it can do stuff, and it can own stuff. It's like a person acting out in Germany, at least. And as such, it is made of money, that is the share capital, that the shareholders put in. So once you have put in the money into the account and the company's entered into the commercial register, then you have a GmbH, and it can act out and participate in the business. And the shareholders do provide the money, and they get the money back, they get the profits, and the people who really run the company are the managing directors. The managing directors is kind of a certain German CEO. If you have like trouble understanding this, just go on YouTube or go check out the other video. It's just fairly simple to see who is part of your company. And the managing directors, one of their main jobs is to have the employees, to tell them what to do and to manage them. So they're managers. And as you see, the employees are part of your hierarchy. So the managing directors are sort of the ones making all the decisions, and executing are the employees. So all of them together are your company. And of course, there are other companies. So there is distributors, contractors, and people that you deal with, competitors. And as you see, this is a money head too. It's an American one. It's got a dollar sign. It's the euro. So it can be anywhere. And this just, the relationships that your company has with those people are very simple. Like let's say you buy stuff from another company, or you hire them for services to, let's say, they build your software. Then it's very clear in the eye of the law what happens here. It's two equal partners doing a trade. So you agree, and it's your terms and conditions and their terms and conditions, and it's fairly simple. The issues only arise when you have to do with freelancers. So as you see, a freelancer just looks like that guy, like that employee, and that is exactly the problem. you cannot really tell whether there is the guy is a freelancer or an employee. And this is exactly where we have a lot of trouble in law. Why should you bother about this? The German term for the problem is Scheinselbstständigkeit. Again, another great opportunity to learn German. Scheinselbstständigkeit means fake self-employment. It's one word. We like to keep it all together in one word. And the reason why this is an issue is that if you don't use the right relationship or the right contract type for employee and treat him like a freelancer, then you do not pay social insurances and wage tax because you think that's his job to do. So he says, I'm a freelancer and here's what I get per hour per month, and that is what you think is your contribution. But if that person in fact is an employee, then what you gave him is less than what you're supposed to do. You should have added or deducted the wage tax and social insurances, the contributions, and they add up to about 40%. It depends on of course, on the salary, but this is a huge chunk of money. So what you could think is, well, I don't care, then I'll just get it back from him. That's not how it works. Like, if you wrongly treat an freelancer like an employee or the other way around, you risk punishment, especially if you know you did it. Because Scheinselbstständigkeit, fake, implies that you kind of try to conceal something, that you're already aware, well, I know he's in fact an employee, but I treat him like a freelancer because I don't want to pay social insurance, I don't want to pay the wage tax. And if you intentionally do that, you risk criminal punishment, and you could go to jail as the managing director, because as we know, the managing director is the guy to blame in GmbH and OG. And of course, you have to pay all of that up to 3 or 4 years retroactively. So the worst case is that you start your company, you hire someone, treat him like a freelancer even though he's an employee, and after 4 years you get an auditing, and they will look into all the past years and see, well, what is this guy, and they determine that in fact the guy that you hired was an employee, and they will charge all that money back from you. And you can imagine 40% of a wage over 3 or 4 years can up to huge sums. And not only that, they will charge late fees, because if you had paid in time, then the state, the country could have used the money. And so it's kind of like interest that got, like, you didn't pay them. And so I know of one case, it wasn't a case of a managing director though, but he had to pay over 100,000 euros. So, and that was only because the jurisdiction changed, which is tough. But this is these are the threats that you have to deal with. So that is your worst case, audit that finds out after years of doing the wrong treatment. So how do you know the status? Again, an even longer word. We have the Statusfeststellungsverfahren, which is the status. Okay, that's English. Feststellung is to determine, and Verfahren is just procedures. You determine this status in a procedure. And again, German makes it one long word. So, but the main misconception that we have here, you don't know it by the contract that you choose. So just by giving a freelancer an employment contract, or by giving an employment contract to a freelancer, you do not change his status. His status is autonomous, sort of, from that. So it's your job as the managing director to pick the right contract. You cannot pick the wrong contract, because that will really have all those implications. So that is a common misconception. People feel like, well, this guy came to me, he said he's a freelancer, and I gave him a freelancer contract, he even showed me his terms and conditions, and that's what we did. No, that's wrong. That is a deadly mistake, as I told you. Like the consequences can be really crucial. So what do you do instead? Statusfeststellungsverfahren, we talked about a little bit when we talked about managing directors. You can do the same thing. You even have to do the same thing with managing directors. And I strongly advise to do the status check. And the sooner you do it, the better it is for you. Because you don't have to pay late fees, because you informed the authorities, and then there is this procedure that can take longer, can take not as long, but you don't have to pay late fees until that it is decided what the status is. And also, you can claim the money back from the employee, which is a really important difference to the auditing. So the status check is sort of like an audit that you do preventively. So it's on your own terms. And an audit is kind of punishing you for doing things wrong, and then a status check is determining the status upfront. So the difference is that you can charge the money back within a certain period from the employee, which is good, because what you did is you actually paid his tax and you paid his social contributions. That's the difference between gross and net salary. It's his job to do so, but you did it for him, and the punishment that you receive when you don't do it and it comes out after like 2 or 3 years is that you can claim it back from him, and he will not pay it, because other than a managing director or a shareholder, he doesn't care about your company anymore. If it's his job to pay the huge sums, and that's exactly what the law intended. They wanted the employer to do his job and determine the status, and not kind of get everything back from the employee after years and years, because employees are used to monthly salary and they're not used to paying 50,000 euros back after a couple of years. So that's why you should do a status check with a German pension fund, and other way around. And until the end of that procedure, you should build reserves. That's the easiest my recommendation, what you should do. So you know, well, maybe this guy is an employee, so you take that sum and put it aside, and so you don't have to, because it of course you don't know the outcome of the status check, so you should set it aside, and so there is no bad surprise. So I told you they do the status check, and how do they do that? How do you know whether the guy is an employee or a freelancer? There is a number of criteria, and it's all like rule of thumb, and there's a lot of things to consider. So there are a lot of indications. The main difference between an employee and a freelancer is like the dependency. So an employee is part of your organization, he's integrated, and he's dependent on you, while a freelancer is independent. And how do you know whether he's dependent or independent? The main point is an employee, you can tell him when to work, where to work, and what to do. So having the MD or the supervisor tell him his job is exactly a good thing about having an employee. Of course, there are limits. You cannot have him work from midnight to 6 a.m. on Christmas or something like that. There are laws to protect the employees, but within that and within what you agreed on in your employment contract, you can pretty much tell him anything. And you can write in the contract, you work in our office here, and you even have to do business trips, and you do your breaks only when I approve it. You can really force them. You're in charge there, and that's totally different from a freelancer. A freelancer is free, and he can work. He doesn't have to accept the job, of course. So he can choose if he works, when he works, how he works, what he works. The only thing that you will always agree on if you have a freelancer, you will say, well, I want this job done. And so his job is to get the job done. It's not his job to sit in your office from 9 to 5. He can sit wherever he wants to, and he can work wherever he wants, whenever he does. It's just that he is reliable for the outcome. So a little bit, there is a blurry line where it goes, but you pay the employee for his time, and you pay the freelancer for the outcome, sort of. Even though there are contracts, of course, like me as a lawyer, I'm a freelancer, and I get paid by the hour sometimes. But sometimes I get paid for work, like for drafting contracts or your terms and conditions or whatever. Of course, you will have deadlines. You will agree on certain milestones, and that is really important because other than an employee, there is no way you can force the freelancer to do so. And that is one big point. The what to do. So if you're not happy with how the employee does his job, you can make him change it. You can make him change his way, and you can fire him if he doesn't in the end. And he is totally dependent on what you tell him to do, while the freelancer just has the freelancer contract as sort of as a frame from where he operates. Next, an employee is hired himself. You never hire him and his family or so. It's just personal work that you do. And while a freelancer can have employees, it's his own choice, and he can even do subcontracting. You may want to exclude that in a freelancer contract. You may want especially that expertise. You want someone who's really good at that thing, and he doesn't just pass it on to someone else. But it's in theory, he's allowed to do so. And whatever he does with his money, with his organization, he can have hundreds of employees. You don't know, you don't care. It's none of your business. And that all kind of ties it together. The employee is financially dependent on you. And that is one thing that people get wrong a lot. Like, if you have a freelancer and he keeps working in your for 6 months full-time at your office, then he is not a freelancer anymore. He's an employee, because there is no way, if he works full-time for you, that he can do any other job. He is totally dependent on that position. While in theory, a freelancer is free to choose several clients. He is free to not only dependent on one client in the end. And he's free to take, of course, a job or not. While the employee has to do what you tell him to do, the freelancer can decide, well, I don't have time, I don't want to, it's not my business. Those are the basic indicators. Of course, there are more. One that is really crucial. An employee has a lot of protection in Germany, and you don't have to put this in the contract because it's already there by law. It's vacation. So in Germany you have 20 days, work days on a 5-day, based on a 5-day week of vacation, statutory. Sick leave, if the employee is sick, up to 6 weeks of the disease where he cannot work, you have to keep paying him. And parental leave, like I don't actually know I don't have kids. I don't know the terms, but it's you have a statutory right, and of course you cannot fire a mother when she got pregnant and everything. But with a freelancer, it's a little bit different because they have their own risk. So you don't share his risk of whatever he's doing with his free time and when he works and how he works. So what do freelancers do? Well, they advertise their own services. So it's always a strong indicator if a freelancer has a website and is trying to get several clients, because if he doesn't advertise, how else should he get any business? So while an employee, in theory, doesn't have to. Of course, you can have your Xing or LinkedIn profile, but in generally, they don't advertise themselves and their services. Last, this is what we're going to talk about in the end, employee participation. It's a strong indicator of an employment if you have an employment participation with him. I know startups who do share that with their freelancers. I'm just saying it's an indicator. So don't take all this too literal. There is no freelancer who's always on the right-hand side and who's never on the left-hand side. It's just like you put up a list of pro and con, and then in the end, they kind of look what's more, where there are more points. That's how they do it in the agency. Oh yeah, and this is the last one, I think. The employee doesn't have to buy anything for himself. You have to give him everything. So he's like your child, and you have to buy him toys, and so you have to buy all the tables and all the computers if he has to use them. And he uses all your facilities. He doesn't have to. You need to give that all to him. While the freelancer is independent, so it's his own duty to do so. So a lot of times in projects, of course, you need to have a freelancer participate somehow. So you need to share your data and stuff like that. That's not what I mean, but more the general idea of whatever expense there is, he has to carry it himself. And of course, the facilities, if you have a barbecue for your employees, then you shouldn't always invite your freelancers, even though they'd like it. Maybe you have to have separate events, just to show that there are distinctions. All right, this is just a list, like it's an endless list, sort of, and just look where there are more on which side. There are a few, like just to kind of recap, there are a few reasons why it's better to have an employee than a freelancer. Like I told you, you can tell the employee what to do, where to do it, when to do it. And this is a good thing, because you want the job done, and then you want to be specific about it, and you want someone who you can sort of enslave, even though you don't, of course, stay protected. But a freelancer, you never know if he's taking a job. He's free to do so, and how he does it, maybe he has his own ways. And you have to be really specific in the contract. So what you don't put in an employment contract, you have to put it in a freelancer contract. You have to tell him, okay, we agree on these milestones. We'll agree on these working styles and whatever. And this is much easier with employees. Second, this is a big issue, IP. Intellectual property. It is sort of understood that if an employee works and he's producing IP, let's say he's a programmer and a software developer, if he's coding, then it's for the company. You don't need a special agreement about that. You don't need special compensation for that. It's different from a freelancer because he is first producing it himself. So you need to have an agreement in place that says, okay, I transfer you, I sell my intellectual property, my code, my logo, the design that I do, and this needs to be compensated. Of course, when you agree on hiring a developer as a freelancer, he will have a salary that is good enough and that usually reflects the compensation, but you have to have it in the contract. So our contracts that we have, I have really long list of what transfer he is doing, what transfer of IP, and this is really, really important because if you don't own the IP, then your company is worth substantially less. And even if you still manage to use it and the freelancer doesn't care, but your investor will care in the end. And anyone who is taking shares, who wants shares, will really have you to prove it that all your IP is yours. And this is something you have to keep an eye on. There is a lot of issues about employment and everything, and there is a lot of minor details, but this is one thing that that you have to have an eye on. Questions in the end?
We can make them at the end.
Yes, yes, yeah. All right. And the last thing, which is kind of some more softer aspect, is that you employees identified with your company, and that is if you have a strong vision of what you want to build and good team spirit. That is something that cannot be overlooked. So an employee who's willing to work for a startup is really a lot of times he misses out on a good salary, and he misses out on security, and but he's willing to do so because he shares your vision, and so he's willing to work long hours, of course within the statutory limits, but he's willing to give up a lot to work with you because he believes in the same that you do, and that is something that you cannot buy. That is a freelancer will never be as committed, even though he's always there, or used to be really, or tend to be very committed to doing a good job, but they're not, like, they have to look after their own like aspects too. So what you can give them is bonuses. So this is a blurry line again. Employment participation, for instance, is a good incentive for staying with you, but it's more reserved for employment, of course. All right, this was the list where. So this was the 3 reasons why you should hire employees, and now the list why you shouldn't. You see the font is smaller, so it's going to be more. All right, so I mentioned it before. For employees, you have to deduct the social insurances and the wage tax, which is 40%. The freelancer has to do that himself. they are not part of the statutory insurances, so they may have to pay less, and so maybe it comes to the same amount, gross net, but it's none of your duty, and what you pay him is all that you have to pay. Second, union participation. In the beginning, you don't have to care about that a lot, but the bigger a company grows, the more involved they get. And if you look at big companies, any company that is on the stock exchange, they all have to have really a lot of regulation about their unions participating and about their employees giving their consent to everything when they hire a caretaker or not. And it's like really, it's really slowing down a company. In the beginning, like I said, don't worry about it, but it will become an issue in the end. Termination protection, that is one big issue, because in Germany you cannot just fire an employee. When the company grows to like 10 employees, you have to have a reason to fire someone. And this is a reason that is in the person, in what he did, or in your company that you cannot afford that person. But it's really hard, because if you fire someone, then and he sues you, first of all, it's free for him in the beginning. And second of all, this can really slow down your business for a long time. And they are very highly protected. So if you cannot prove that one of those reasons was the case, then he will stay in your company, and you need to really pay him off dearly. Of course, if he's stealing from you, you can fire him immediately. There's no excuse for that. But in most cases, when you're just not happy with the performance of a person, you have to prove how their performance is worse than others, and it's really a pain. It's really hard. With freelancers, you have a contract, and you can even put termination policies in there to say both parties can terminate the contract within 2 weeks, and then it's terminated and it's gone. And if you don't like it, then you don't hire him, and there is no issue with that. So termination, the bigger a company gets, the harder it gets too, and that's why a lot of contracts have trial periods in the beginning. We'll talk a little bit about that later, but that only helps you for the first couple of months. Okay, employees do get minimum wage. In Germany, I think it's 8.75 since 1st of January, euros per hour. And this is, if you want cheap labor, you have to think twice before hiring someone with minimum wage, because they're highly regulated. There is a special agency for them. And you have to register the employees. You have to keep track that they do at least get the minimum wage, and it's really, really a lot of regulation here. And of course, if someone doesn't work on regular shifts, then he needs to have vacation. Like I said, he needs to have sick leave, and he shouldn't work on holidays. And that all needs to be priced in that wage. So if he doesn't work regularly, you kind of have to have an estimate of how many hours or per week, per month you did work. It's really, I had cases where this is more complicated than just paying more. Just pay more and then you're happy. Also, you don't even have to pay the minimum. You have to pay it monthly. So if your company is not doing well, then you still have to pay that person. With a freelancer, you can kind of make short contracts and see, well, we try out this project, and then you don't continue it. You don't have to have a freelancer at all time. It's just on demand, so to speak. This is something that is really painful too. If you only have a few employees, in theory, they can ask you to work part-time. So the bigger the company gets, the easier it is for them to have that claim. So I think most people are not really aware of that. I think it's more for public offices or so, where people tend to work more part-time. But it's you have a legal claim to do so. You hire them full-time, and after a year, they come to you and say, "Well, I want to work 50%," and then you have to hire someone else again. And it's really it's all those employment protection parts that really bite you in the end. And like I said, claim for sick, parental, regular leave, this is something that freelancers don't have. It's their own risk, so they insure themselves. And it's not your problem. And this is the last point, no discrimination. The discrimination part is, it's like a basic law, a Grundrecht. You cannot discriminate an employee. More so, like you cannot, of course, just put in your ad, I only hire male white people, Christians. You shouldn't. This is obvious that you cannot discriminate that, obviously. But also, you cannot have unequal pay. Like if you give one employee a treat, you need to give it to all the others, unless you have a certain reason for doing so, and you have to prove that. And that will come in interesting too with the employment participation. You will hand out shares or options, and you will have to have a reason for giving that one employee more than the other. And because of that, Gleichberechtigung, like equal treatment. And of course you don't have that with freelancers. They don't know what any other freelancer gets, and it's like all your negotiations. So these are the reasons why hiring freelancers beats hiring employees. Of course, I'm a freelancer, so you should hire me too. But one special case that I haven't mentioned is working shareholders. It kind of like this is the most complicated case. I just want to wrap it up, because most likely your first employee is going to be a shareholder. So either you are the managing director, and we see the managing director has all the employees under him, so a shareholder can become a managing director, or, which is always an option, if you want to have a shareholder who's not a managing director, he can, damn it, it's the other way around. So he can be an employee or a freelancer, and this is rather complicated, because other than an employee that is not a shareholder can influence the company. And so the determination whether a shareholder that is working for the company is an employee or a freelancer is much harder. It has to do with the shares, with voting rights, and we'll get to corporate law again. So if you have an issue with that, just let me know. Just 2 words, that if you are the majority shareholder, then you are a freelancer. And if you are minority shareholder, you're more likely to be an employee, but there's things you can do. So there are ways to get around that. Okay, and third, which is a solution for some people, the shareholder can just found his own company where he's the only shareholder again and the managing director, and you contract with that company. So let's say you have a shareholder who is a developer, a software developer, then he will found his whatever UG, software development UG, and you have a contract with them. So in the eye of the law, it's absolutely clear that this is an equal relationship. There is no employment involved. And also, if he's the managing director of his own company, he is also self-employed because he's 100%. He is the only one. But just a quick warning, if that company only has one client, that company, then the law found that this is kind of a way to avoid social insurance and taxes. So they have an exception for that, and they say, we understand that you as the managing director are self-employed, but you have to insure yourself too. So you have to be insured. You're sozialversicherungspflichtig. So basically, there is no advantage to avoid social insurance if you want to do that. But if you have several clients, then it's different again. Then you're just a regular company. So now that I confused you thoroughly, I just say, let's leave this topic. Let's go to the employment contract. That's easy. So what you want is in an employment contract is just a few basic principles. Always start it in writing and end it in writing. Just the way you started, the way you end it. And it's not obligatory by law to start it in writing. You can just go to someone on the street and say, come with me and let's work. But especially if you have a limited contract, it has to be in writing. Otherwise, it is unlimited. Also, if you don't have any agreement, then it's really hard to prove, like, IP stuff and what the person is supposed to do, compensation. So if you don't have any agreement on the compensation in writing, then well, he's gonna ask what the average is entitled to. And there is just a lot of issues that you get. So my advice is start it before you start the work. So let's say on 31st of July, you have the contract signed, and then the start of work is 1st of August. Don't have it the other way around, because it just makes it more complicated. Okay, like I said, limitation. You can limit the contract without any reason for up to 2 years. I think there are some, for startups, there are some special rules too, that makes it even easier. I think up to 3 years, but I can safely say that it's 2 years. And after that, those 2 years, the contract ends immediately and you don't have to do anything. On the other hand, you can have an unlimited contract, and employees like unlimited contracts because it gives them security. But on the other hand, in an unlimited contract, you can terminate without cause in the beginning too. So it's maybe some false security that people get. So you have to kind of know what people are more comfortable with. If you have a trial period, you can you can terminate the contract without cause with a 2 weeks notice in the first 6 months. And our contracts do have that trial period, because in the beginning you have to try out if something works for you. So our contract template is unlimited with a trial period. And also, as long as you don't have many employees, like I said before, there is not a lot of protection. So maybe you don't want to do that, but I just wanted to let you know you can limit the contract just like that. And then you could extend it under certain conditions. Third, like the law is pretty old-fashioned, and it thinks that we still work from Monday through Saturday. Those are all labor days. And that's why the vacation law, the Bundesurlaubsgesetz, and the I think the Arbeitszeitgesetz, the working time directive, they still take as a base the 6-day week. So if you have a contract on a 6-day week, people can work up to 48 hours regularly. If it's 5 days, Monday through Friday, it's 40 hours. So I know it's not socially accepted in Germany to work Monday through Saturday. I'm just saying that it's possible. And I mean, it's more honest having people work that long than having them work from 9 to 9 at night or so, at 12 hours every day, which is illegal. Like you cannot do that. So it should be 8 hours per day and maximum, and only in certain times 10 hours, but you cannot have them work longer. So I think that is like only doctors have exceptions or so, which is beyond me why doctors who treat sick people, out of all people, have to work longer in some periods. But most employees don't have to work that long. And you can get extra 25% of unpaid overtime, never more. It's kind of a max if you agreed on it. So if you put it in the contract and it's in our contract, then it's fine. But of course, you should try to get it kind of balanced out by having free time to the employees. All right. So what are the steps of employment in Germany? As you see, there is a threshold, no employment, employment. So what you need to do before employing someone is, of course, the interview. I told you shouldn't discriminate by race and so on. And you should, like, also in the ad, like when you put it up, it always has to be female, male, and it should be obvious that you only want young people. Even though if you say, well, we have Club Mate, then it's obvious that only young people will apply for that job. And like I said, again, don't have them work beforehand. If you want them to try them out really like on a training day, then have a training day signature, like a one-pager, and just so it's obvious. So now you see, this is before the employment. So the signing is the day before or the week before or whatever. What you sign as the employment contract, you sign a data privacy declaration. We'll get to that in a minute. It's really easy and just something that you need to respect, and then it's all. And you could sign the ESOP, the employment participation. and the vesting could start at that day. You can, of course, the last point, you can wait until you kind of tried out that person and you know that you want him to participate in the success of the company. Third, regulation. So now it's getting, again, bureaucracy. We have an employment office in Germany, and you have to, before you hire the first person, you have to have a business number. So I think you apply for it, and then there's 3 days, and then you can register the first employee. So there's a certain time that you need to respect, and you have to provide them with all the documents about the employee, because you need to register the employee too. I don't know, like look it up on the internet. It's really a long list of stuff that he needs to apply. And then you need to register him with the tax authorities, with the employment office, and with insurances. So there is an automatic accident insurance and there is social insurances. So that's all you have to do when hiring someone, the regulation. Fourth, that's just as a reminder, so every month you need to pay your employee, of course, and you need to deduct the salary, the wage tax and the social insurances. Because if you don't, like you could get in serious trouble. Like even like what I told you before about the consequences of hiring a freelancer as an employee and the other way around. This is the same thing if you have an employee and you know, but you don't deduct the social insurance and the taxes. So that is criminal, punishable by law. So, and then there is the trial period. Like I said, it can be up to 6 months, and it's just easier for you to terminate the contract in that. Of course, you don't have to have it. All right. The data privacy declaration that I mentioned, you can also find it on the documents. It's not part of the employment contract because it affects all contracts that you have, also with freelancers. And the reason for doing so is just a declaration by the party that if they deal with private data, that they respect the law and that they're aware of it. The private data, what is a private data? It's like anything that can be like traced back to a person, like the name, sex, even the IP address is private data. So we can have a whole lecture about a workshop about data privacy statements for your website. This is not a data privacy statement. This is just a declaration that your freelancer or employee or other partner has to give if he's dealing with your employees' data or with your customers' data, because you're obligated to respect that. And of course, you are already obligated by law, but if you have other people who are not you, then they have to show that they understood too. So data privacy, very important in Germany. All right, and just attach it to the contract, and that's all I'm going to say about it. All right, freelancer contract. It's just a very short section because it's very individual, and the template that we put out on legalstraße.com is already, well, has most points that are already integrated in it. Okay, so again, you find it on the legalstraße.com section, and these are the main issues. So just as a reminder, status check. Just do it if you're not absolutely sure that this guy is a freelancer. Because you will have security, you will know from the beginning, and you can claim the money back from him if he's in fact an employee. Second, IP, big problem, like I mentioned also before. The freelancer is not producing IP for you, he's first producing it for himself, and as part of the contractual agreement, he's transferring it to you. And this is already taken care of. I just want to remind you that this is one big issue. And third, this is the main thing that you have to kind of do yourselves. You have to find out who's giving more or who's taking more risk, because you have an exchange, you give the money and he's giving you the work. So at what point happens what? So do you pay him first and then wait for him to complete his job, or do you agree, which I would recommend, on sort of milestones, and then you say, okay, on this day we transfer your IP, then he still keeps his IP until that point, until he has the money, and then it's all done at one point. Of course, you can try to get the IP right away, and you can try to work him pay him later and have him work first, but it's fair trade would be to have it kind of at the same time. So he works, and maybe you give him a prepayment of some sort, and then the full amount only at the time of the transfer of the IP, because most freelancers actually do produce some sort of IP for you. All right, good. So now employee participation. This is kind of a separate section because it has a lot to do with corporate law. Again, you find it on the section on the legalstraße.com. What is employee participation? You don't have money, I assume, and so you want to share the value of the company, the future value, in order to incentivize your employees to join your company, to keep working in your company, and to keep working well, so they perform. So since you cannot pay them a huge salary, and just besides the Club Mate, not anything that another company can offer, you want them to join your vision and to believe that your company is growing strong, and when that happens, they want a share of that. So they don't get monthly salary incentives. Of course they do, like at least the minimum wage, but they get the company value incentive. That is the participation. They're participating in the company value. All right. So there are two main concepts, and there is a lot of abbreviations that are really annoying. I called it ESOP in the beginning, just like meaning employee stock ownership plan, and which would imply that employees are owning the stock. It's kind of a broad term. Some people say employee stock option plan. So that would be an option. It's just, don't get stuck up on the words. It's really confusing. But there is one that is more obvious. It's the VSOP, and that's the one that I am suggesting. It's a virtual stock options plan or program. And we're going to talk about it in a second, but the V always stands for virtual. And here the O must be options too. Don't get confused by that, even though there are just so many words, so many abbreviations about it. Here are the main three concepts that there are out there, and I will tell you why the VSOP is the best one. So what you could have is shares. So you remember the GmbH with the shareholders. If you choose shares, you make an employee a shareholder of your company, and that is real shares. And they're kind of like co-founders in that perspective. So it must be really important employee, so you give him shares. He's just like, if you're the founder, he's like one of you, you know? Share options, you could say, well, employee stock option program, then this is the right abbreviation for that. But the concept here is you don't give shares, you don't give him the option to get shares later. So that has clear advantages because he's not a shareholder right now. So he doesn't participate right now, only in certain conditions, and that usually is the exit. So the exit event is normally the sale of the company. If you sell the company, then they define what a sale means. Then this person, the employee, can execute his option and get shares. And now the third option, the VSOP, the virtual options. So this is not even like, it's not an option for shares, it's an option for the equivalent of shares. So this person will never receive a share, they will only be treated as if they had options for shares. Okay, so this is like a third degree of getting away from being a shareholder. He's not a shareholder, he doesn't get ever shares, he just is being treated monetarily like he participated as a shareholder. So when the company is being sold, we pretend like he owned 1% of the shares or 3% or whatever, and give him that money only then. And this is a good idea. That's the reason that the red parts show you when something is not good, and the other ones are fine. So for the employee too, when he receives shares, he has to be taxed on them. And that is a big issue because let's say you start your company and after 2 years you get an employee and you want to give him shares, then your company is already worth something. But of course the employee doesn't want to pay that. Let's say your company's value is 1 million and you give him 2%, so that's 20,000. And you just want to, you give him as a bonus. 20,000 is the value of the share that he would receive, but he only wants to pay the minimum, which is the nominal amount of, let's say, 20 euros. So he will receive 20,000 euros, but only pays 20. So the tax authority thinks, well, you just gave him 19,980 euro for free. And that's what we're going to tax you. And so he has to pay almost 20,000 euro taxed like 30-40% right away. And he doesn't have the money, he doesn't want that. So it's not good for him, it's not good for you for other reasons. While with options, you never know when the exit is going to be. So that's why the tax authorities think, well, we'll only tax him when he actually exercises the option or when it's really imminent. Also, which is the main differentiator between the two on the right-hand side, is that for some tax reasons, I don't know, I had it explained, but I don't really understand, you can deduct the virtual options and you cannot deduct the employee stock option. So the employee receives more net because for the company it's sort of business expenses. So if you want to spend a certain amount, then the employee receives more virtual options. If you have a shareholder in your cap table, then he has participation rights. So your employee will sit at each shareholder's meeting and he can ask information, he can make suggestions and he can vote on them. And he will of course also get all the profits that you make. Well, in the beginning probably you're not making a lot of profits, but he is participating like a full shareholder, and that is really dangerous in a sense and also giving away a lot of power for you. And last but not least, the notary is involved with the two left programs, because when you give someone a share, you need to go to the notary. So it's the law. If you go to give GmbH shares, it's necessary. And with the share options, you usually secure them with approved capital. And so for that, you need to go to the notary as well. And then in order to execute the options, the share options, he needs to go to the notary again. And so there are more costs involved. So this is a lot of words, so let's put it into pictures. So here's my takeaway. So if you want happy employees, then the shares are probably the best option because you give him a lot of power. You give him profits, you give him the exit, except for the tax aspect. They're really happy because they are really part of your company. With share options, well, they feel like they participate in the whole development of the company. Maybe a little bit more than the virtual options, because virtual doesn't sound very participating. It sounds like kind of like a trick. But in the end, it's not, because the difference between ASOP and VSOP or the middle and the right one, in the end, is the employee will never have the shares, even if you choose share options. Because what happens typically, you have a buyer, and the buyer says, I want all your shares, or I want at least 50-55%. And then you tell him, yes, of course, you're going to have that. And then you're going to, either the buyer buys the options, or you force the employee to sell his options or his shares with him. So it's for one logical second he will be a shareholder, and then he will not. So it's kind of the carrot, that you wave in front of him. He's never really going to be a shareholder, but of course it sounds better to have the option to get real shares than the option to have virtual shares. Maybe that psychologically makes a difference. But now the reasons why shares are bad, like it's really costly, like not only the taxes that the employee pays, but also the profits that you lose, because you have to share the profits with your employee, and the notary fees that you have to pay. And with the share options, you only have to go to the notary. Okay, that doesn't have to be that expensive for you. But virtual options, actually, you don't need to go to any notary. Just get the contracts out, and it's set up. And now the real reason why shares are a bad choice, it's really risky. It's incredibly risky to have someone on your cap table who is none of your founders, so none of your co-founders. A lot of things can go wrong. He can oppose an exit. He can say, oh yeah, well, I don't feel like selling my shares. And he can always try to get at a shareholders meeting. He can really block or have a veto right in some, if he's got enough, or if the articles are not good enough. If your bylaws allow it, he's got a lot of rights. And you cannot change your articles of association in the aftermath. So let's say there is some way you want to give a drag along, right? Drag along means you may force him to sell with you, which I explained before. If you want to introduce that, you cannot do that against his will, even if he's only got one share, because it's kind of depriving him from his basic rights as a shareholder. So even though you have majorities and you don't worry about that, there are certain things you just cannot do with a shareholder, even though he's only got one share. So that's highly risky. Share option is of course, is less risky, but there is still the risk that something goes wrong in the exit event, because he's entitled to the shares, in theory, even though you want him to just sell them with you. That's the risk that can happen. Of course, if you have a good contracts, everything will be fine. With virtual options, there is no risk. Like, you know how much the participation is, and you have to pay it to him. And there is, it's just the easiest choice to go. So this is why it gets the check mark. All right. So the question was why the euro sign was only one and the virtual option, because you don't have to go to for me the euros is just the expense of the company. So it doesn't get. Like, you don't have to, maybe you don't even have a euro, because it doesn't cost you anything. But while the share options, you have to go to the notary. You have to do the first for setting it up, and then again for the execution, which you don't do in the virtual options. Okay, so that's my favorite. Here again a little a graph showing you how options work. So this is the hockey stick that we're all looking for, like the share value, how your company is valued over time. And you all start, like, one share in the beginning is worth €1, because that's the nominal value at the time of incorporation, and then it grows. And let's say after a year or so, you grant the option. From that moment on, he's participating in the growth until the exit. So what are the values of the option, and what does the exit mean? The option value is just the share value, which is the orange graph, minus the strike price. The strike price is exactly always the same. It's, in this sense, I think €10. So at the moment of the grant of the option, when you give it to the shareholder, your company is worth €10 times your shares. Then this option is worth nothing, because 10 minus 10 is 0. But from that on, let's say you get here to the exit with 50, then the option is worth 40. It's pretty obvious. And the options that we talk about, they have to be triggered, so they cannot just freely use their option, execute them. They only can execute them when there is an exit event. Okay. So what do you have to do for your options? You have to determine how many you give out in total and how many you give individually. And of course the strike price. I would advise you to use the value of the company as the strike price, like we did on the graph, but you can always set the strike price at €1. So even if someone comes after 2 years, 3 years into your company, you can still pretend like the company was worth nothing. Just keep in mind that you cannot discriminate, or you have to treat all employees equal. So with 2 people coming in year 3, you cannot say, well, the strike price for you is 1 and for you it's 20. Then it's obvious you don't treat them equally. But the more, and this plays an even bigger part in the individual number. So if you have 2 employees doing the same job, then you really have to have good reasons for giving one 1% options and the other 2%. you have to have some objective criteria for that. You cannot discriminate, because that is kind of the risk that you have, that someone will complain and ask you, because it's a bonus, and bonuses have to be on grounds and solid grounds. And also, of course, you have to keep in mind the total number. Like for option shares, it's usually between 10 and 15% maximum, which is the investors like more, but the founders like less. So yes, that's the first part. That's what you have to decide. Second, the vesting criteria. We talked when about founding your company, we talked about vesting. Vesting meaning they have to earn their options, because you're basically giving them for free and as a bonus. So you want it to, as an incentive to stay with your company, to work well, to keep performing. And that's why vesting has a lot of criteria how they can get it. So how long do they have to keep working? Do they get something if they get out after day one, or do you have to wait a certain cliff period? We'll talk about these points also in another graph, and also about double trigger and stuff like that. And third, the exit. It's just the exit compared to let's say the lever. Don't mess that up. A lever is when the employee leaves, and an exit is when kind of the company leaves, because it gets sold. So exit cases usually just the sell of the company, or an IPO could be an exit case. So you have to define for yourself when do you want an employee to participate, but those are the classic cases. So either the company, the shares get bought, that's a share deal, or the assets of the company get bought, like all the IP and all the facilities get bought, and that's an asset deal. And an IPO is when you go to the stock exchange. You also have to keep in mind what happens with dilution. So if there is an investor coming in, do the options get diluted or not? So is 1%, does it stay 1%, or does it become 0.5 if you get an investor in and stuff? And also a liquidation preference, because when you deal with investors, they will often ask for preferential treatment. They will want more than what is theirs, actually. And they want to be, especially like if the deal goes, like if you don't have a good valuation, then they want to make sure that they get their money back. So they want preference in that, so whatever remains. So here we can see in a graph how this works with if an employee stays with your company. So it's a loyal one, the good employee. Here is the number of years and the percent that he vested out of his options. And so you start off with 0, of course, and for the first year, which is the cliff period, he doesn't vest at all. But then all of a sudden at year 1, he already has 25% because he kept working. And this is because we have 4-year vesting. Yes. No, 3-year, actually. 3-year vesting, okay, sorry. So we have 75% max as a ceiling that you can reach over 3 years. So this is 75 and this is 100, 50, 25, 0. So after 1 year, you have 25%, and then it just goes up to 75% in year 3, and then he doesn't vest any additional, so he's already got it. But let's say there is no exit event until year 4, then he will receive these 75%. Now is finally when he can execute his options, and he will get the money that is the equivalent of if he had that amount of shares. But what we want to do is we want the employee to stay with the company. So this is called a double trigger. So you have the first trigger with the exit, and the second trigger is his obligation to keep working for the company. So it's another incentive for him to get an extra 25% if he keeps working for the company for 1 year, because this is of course good for the employee if he gets more, but it's even better for the buyer, because the buyer, oftentimes you have few employees who are really key to the company, and the buyer doesn't want to buy an empty shell where all the employees leave right the minute it's being sold. So this is an incentive for the buyer to say, okay, this company will have a lot of key employees who have been here working here for a couple of years, and they will stay because they get an incentive. So I would recommend definitely a double trigger, his obligation to do so. How it's being done technically is that you keep the money for him in a trust account for the 25%, because the event is actually the exit, and you say, well, here's 75%, but if you want an extra 25, then please fulfill your contract or keep working with the buyer. All right. Here's a case where we have a bad employee. He's leaving at one point. So the beginning is the same here. After 1 year, he's got the cliff. And then he will leave after 2 years. So he didn't vest fully. And what we have here is, of course, it's a good leaver. So there's always good leaver and bad leaver. Good leaver means, well, we parted ways, and it's an amicable divorce. And a bad leaver is really, really bad. And bad leaver is like he stole from you. So if someone steals from you, he doesn't get anything. So that is the usual way it's being done. So bad leaver would be right down to zero. The minute he leaves, he doesn't get anything. And a good leaver means, well, we still stay friends, so you can keep the shares. What you can do is you can just have it at 50%, but like to be fair to other employees, you could say, well, you participated in the growth of the company, but only until here, so your participation will decrease over time again. So what you earned in 2 years was not worth that much in 3 years. So you will lose again some shares, some options. And what you should do probably is have a floor. So that's the minimum amount that the employee gets for his participation after all. So there was the ceiling, which is the maximum he will get investing, and then there's the floor, the minimum that he will keep if he stays in the company. All right, and so since he hit the floor already before the exit, he will get exactly that amount in the exit event. But of course, there's no double trigger, so he's already out, he's not coming back. So, okay. All right, actually we're done. So this is all the contracts that we covered. So first the employment contract, then the data privacy declaration, which you have to attach to the employment contract, but also to the freelancer contract if you deal with private data, the freelancer contract, and now the employee participation. So I think you're ready to grow. And let me just give you a quick preview. The next workshop, I don't know when it will be. We have to determine it. But it will be about funding. So you have all these employees, and they need to be paid. And so how to pay them is the next step that we'll talk about. It's especially about how you can finance yourself, and with a special emphasis on the convertible note. And also when you get an investor, like term sheet hacks. So what you have to keep in mind, how you can deal on a term sheet. All right. So thank you so much for listening. And now you are free to ask any questions, or just afterwards if you want to private.
Thank you. Well, first of all, thank you very much, Daniel. This was super helpful. So I have a lot of questions, but I will start with the most important one I had about the IP. So you said you need to have the IP transfer. But what about the typical case when a friend of yours is helping you out? Mm-hmm. Then there is no contract, actually legally, then he keeps the IP if there is no transfer, or how does it work there?
You have to differentiate what's actually happening and what the legal situation is. So the legal situation is, as long as he hasn't transferred it in any way, then it's still his. And the way that if you don't have a written contract could be implied. So the law acknowledges that not everything needs to be in writing, and that we can communicate orally. So if you say, well, no, it's yours, then that's a contract too, in a sense. But then again, if you don't have it in writing, of course you have to prove it. So then maybe it's just your word against his. So that will be an issue then. Also, if you pay him for, and it says in the bank statement or on the invoice, if you have a written invoice, it says for the coding and publishing something, or for designing the logo. I think it can be implied that the logo is transferred to you. it's just not clear how and where and when. So what he could say is, well, yeah, you could use the logo for a year in Germany for one type of media, and then you get into trouble if he charges you more. So that was the legal sphere. Of course, how people actually work is that as long as he doesn't ask for anything, there's no problem. It's just you will get into trouble the minute of when you get both disagree, and when there is an investor or some shareholder coming and wanting to decrease your valuation because they say, well, how can you prove that this is your IP? And if the logo, for instance, is really big part of your value as a company, then they will want proof of that it's yours. So even if you had done that with your colleague, with your friend, I would still advise you to have a written declaration saying, okay, the parties understand or agree that the IP was transferred under these conditions. And it doesn't have to be at that time, but of course it should. But you can still repair the damage, and as long as you're friends. Okay.
Yeah, I have a question of this situation. If you have a shareholder that is also a managing director, does the company treat this managing director as an employee? For example, does the company have to pay a minimum salary to that managing director?
Yeah, so those are actually two questions. The second question, no, you don't. As a managing director, you don't get a minimum salary because you're not. You're not an employee, but you can be socially obligated, obligatory, which is similar to an employee. So as a managing director, you're the boss of the company. So you're never considered as someone who's dependent. And that is the harder question. I would advise you to watch the YouTube video from last time, because we covered a little bit the social status of a managing director. It's got to do with your shares. And if you are the majority shareholder, then you're self-employed at all times. If you're the minority shareholder, then you can be self-employed, but you can also be an employee, considered as an employee, even though you're not. It's the terming is rather confusing, but the consequences of not being self-employed are the same as for an employee. So you could rather say as a managing director, you're either self-employed or you're not. That is more accurate, because you're never an employee, even though you have to get insured by the company, and which is similar to employees.
Okay, thanks.
And just a short question: what are the specialities of your contracts? I mean, on the webpage, you wrote the contracts, right? Mm-hmm. So if I go to the library and get a book with standard UG contracts, like Muster, I mean, is there a difference? Specific for startups?
Well, yes. You will not find any of those contracts in a book, but you will find a lot of clauses very similar. And those contracts are tested in time, so they have been around, and there are a lot of reasons why some clauses are inside the contract and some are not. And some, let's say you get from a book, you have to choose yourself whether you include that one passage or you're not, and they give you options. So I already did those options for you. Also, of course, you can just comment and ask what that does mean, or you can send me an email or so, and we will just, maybe some other people will reply too, or maybe I will. So there are some clauses that are really, especially for startups, especially in the bylaws of the company, and the distinguishing between bylaws and shareholders agreement. And also the managing director's contract is written for you as a founder. So you could have a managing director's contract that is if you hire an external managing director, so which would be an employee. If you have that, then I would totally advise differently than hiring yourself. because you want to protect yourself as the managing director, for instance, and you don't have to protect a managing director who is not part of the shareholders. So they are tailored to startups and to the issues that, from my perspective, are the main issues for startups. But of course, they are not the most extensive ones. So you can always have. I put certain emphasis. So, for instance, on IP, I put emphasis in the managing directors and employment and freelancer contract that the IP is being transferred, and also on the social status of the managing director and the freelancer. So those are the main issues that I covered there. But others less, especially like if you have certain specific requirements, then they're probably not on there. Yeah.
This one is about the freelancers. So the Shine something, I don't remember the correct name now.
Scheinselbstständigkeit.
Exactly. So if you do that as an employer, as a mistake, you pay. But I mean, the freelancer / employee, he also made a mistake. So maybe he might want to take advantage of you using the clause. So does he also pay something for the mistake is done, or the costs are only on the employee or on the employer side?
So with the Scheinselbstständigkeit, you pay the cost as an employer. It's like the reason being there is employment protection. So the law feels like you as an employee, you don't know, you are helpless, and you didn't, even if you participated in that fraud, then it's not your fault. You are not to blame, and they always play the stronger one, which is the employer. And if you do a status check, then you can get the money back from the beginning and easier. And if you just get in auditing and it comes out after a while, then you can only charge back the last couple of 3 months or so from the freelancer / employee. And so the risk is absolutely yours, and like it could even be an advantage to the freelancer or to the employee to disguise as a freelancer, even though, well, he's not gonna. The relationship between you could be better afterwards. So, yeah. Okay. All right. Thanks a lot. So you can approach me in private now.
Que la famille.